JPN would actually have records of it. So there is a way. The question is, what if one of the nominees passed away and no replacement nomination done? So let's say I nominated 3 persons and one passes away and I'm still alive, one passes away already, and then I didn't know about it, or I got too busy, I didn't have time to go and deal with all these things, and then I subsequently pass away. Okay, so what will happen to my policy? Does the insurer then pay my policy monies to the remaining 2 nominees equally, or they still pay to all 3? So the nominee that passed away, they pay to the nominee's estate, or how? Can we have it in the chat? Just type in what you think. So the question is, what if one of the nominees passes away and no replacement nomination is done? So I nominate 3 persons. One person, A, passed away, B and C still around. So if I pass away, the policy monies goes to B and C, or goes to A's estate and B and C. Okay, so in this case, I'm assuming that the nominee predeceased the insured person. Okay, so we got some answers, varied answers. Yes, okay, yep, correct. Most of you got it correctly. Very good, very good. So it's to share amongst the remaining 2 nominees. The policy monies will be shared amongst B and C. Okay, so this is a very stark or significant difference from IFSA. Under IFSA, your takaful policies, under IFSA, they actually said that the nominee that passes away, that portion you need to pay to the estate. My estate. So if I buy a takaful certificate and I do nomination to A, B, and C, and A passes away before me, B and C will get their 33% and 33%. The remaining 33% pays to my estate, because the takaful concept is different from insurance. So that's just a fun fact for you to know lah. Okay, so for insurance purposes, it will go directly to the remaining nominees if no replacement nomination is done in time. All right, great. Okay, then it comes to the issue of trustee. Can we appoint trustee? Yes, as a customer, we can. If we don't want to appoint, can we not appoint? Yes, that's possible as well. I can literally, as a customer, appoint anyone apart from myself. I can appoint anyone apart from myself. And what if a customer comes to you and say, I don't want to appoint nominee lah? Can or not? Quick answer in chats. And if no trustee appointed, what will happen? Yep. And if no trustee is appointed, then what will happen? So if I buy a policy and I've done some nomination, and then there's a trustee section under the form that I don't fill up, what will happen? Yes, we see some answers that one of it says that the nominee will be the trustee. Another one says it's the public trustee. And then some say estate, nominee will be the trustee. Surviving parent is trustee. Okay, so in a situation where I have made a nomination and I don't nominate trustee. So okay, I do nomination, but I don't appoint trustee. What happens is the nominee will become the trustee. Okay, so this is provided for under FSA, so it's automatic. So for customers who don't appoint a trustee, then the nominee will become the trustee. Right? Okay, so the second scenario is that if there is no trustee and the nominee is a minor. Yeah, because I see some of the answers you all have indicated whether or not it's an adult nominee is an important point. That's correct. Yeah. So if the nominee is an adult, then of course he or she can become a trustee. But what if he or she, the nominee, is actually a minor? Then who will become the trustee? So someone said that the surviving parent of the nominee will become the trustee. Parent will become trustee, parent will become trustee. Yes, absolutely right. So the parent of the nominee will become the trustee. Okay, so now make it complicated a bit. If there is no trustee, the nominee is a minor, and the nominee has no parents. So no surviving parents at that time. So then how? Who becomes the trustee? Public trustee, yes, absolutely. So it'll be a trust company or a public trustee. If there's there can be a trust company that's nominated by the policy owner, otherwise it goes to a trustee company, right? So this is something that maybe you want to bear in mind when dealing with your customers. So if they ask you questions, when they do a nomination, it might be good for you to double check, right? This nominee, is it a minor? Is it not a minor? If it is a minor, customer might want to know that, look, if it's a minor and if anything happens while the nominee is a minor, then this is going to happen. So if you don't want this to happen, then you need to do something else and fill up the trustee portion. Okay, all right. Thank you very much for all the answers. Right, now, once a trustee has been appointed, then the policy owner, once they want to revoke or vary the nomination or surrender the policy or assign the policy, they will actually need the trustee's consent. Unless, so there are exceptions to this. So general rule is that once I appoint a trustee, anything I want to do, I want to change nomination, I want to surrender the policy or assign the policy, I will need the trustee to consent first before I can do. So that becomes a problem where a lot of people, where the husband buys the policy, appoints the wife, then later on they get the divorce, then the wife doesn't agree. But there are three exceptions. Unless I am changing or adding, unless I am adding my spouse, child, or parent as a nominee, in that situation, that limited situation, I actually don't need the trustee's consent. Okay? So the law actually protects the family unit in that sense. Okay, so that is the exception, the general rule and the exception. Okay, so this is a question that is quite, the next question is actually quite interesting and recently come out a few times because times are bad with MCO and COVID and all. There's quite a lot more of bankruptcy issues. So the question is, what if a nomination is created to defraud creditors? So you might have customers coming to you and say, you know, I got all these monies and I have my company is not doing well. I don't want these creditors to get my money in case something happens to me. I want to buy the policy and nominate my kids so that my kids get all my money. And then if my business up, right, not too bad for the creditors, they cannot take all this money. So what happens if it is found? Of course, this one, the biggest issue is can prove or not. Okay, whether we can prove that there was such an intention to defraud. So if it can be proven, that this nomination was made so that the insured can avoid paying the creditor, is to try to defraud the creditor. If it can be proven already, what will happen? Someone say void. What will happen to the nomination? Okay, so let's say a situation now, I have like this person, like this customer comes to you and say that I want to set up this nomination, this policy and this nomination so that my creditor doesn't get my money if something happens to me. So they set up nomination and nominated the children. So now the insured passed away. And it is somewhat proven that that was the intention when the insured buy the policy. Okay, so what will happen? Can the creditors now come back and say, hey, your intention was to deprive me of the policy money. Now I can prove already. So I want to void your nomination. I am entitled to the policy money. So can the creditors come back and take it from the nominees? Yes, someone said yes. Yes, okay, yep, okay. Some say no. Okay, that's a good thing. At least I have something of value to contribute. Some say yes, some say no. Okay, right. So the answer is this. The creditor has a right to claim some monies to the extent of the premium only. They cannot claim the entire sum insured. So for example, if this insured actually used 5,000 ringgit, paid 5,000 ringgit premium to buy this policy of 1 million sum insured policy, okay? If it can be proven that the purpose of buying this policy is to defraud creditors, the creditor comes in, creditor is entitled to take that 5,000 only. Creditor is not entitled to take the entire 1 million sum insured. Okay? Right. The rationale is quite simple because the 1 million is not really the insured's money. The insured's money that took out to pay for the policy is only that 5,000 or whatever premium amount there was. So the creditor is entitled to that money that the insured used, instead of paying the creditor, he used to pay this policy. Okay, so creditors will get 5,000 or whatever premium amount there is, and then the balance should still go to the nominee. So what legally we're trying to say is, legal position is the nomination is not entirely void. It just nominee have to take after deduction of the premium, and the premium amount will have to go to the creditor. Okay? Next, so when we have a nomination and we want to pay to the nominee, what will happen? So the insurers will, upon receipt of the claim and proof of that, will have to pay to the nominee. I mean, that's the whole purpose of having a nomination in the first place, right? Okay, so the question is that if insurers knows about the death, but no claim is made within 60 days, so what will happen? So if insurers know about the death, but somehow no one has put in the claim, so what does the insurer have to do? Insurers will have to immediately notify the nominee at the last known address. Absolutely, someone said send letter. Yeah, so insurers will have to notify the nominee. So this is of course under the pretext that insurers knew about the death. If the insurers didn't know about the death, there's nothing they can do. Okay, so once they've sent out the letter to the nominee and the last known address to remind them or to tell them that, look, there is this claim that could be made, and please make it as soon as possible, they then wait for 12 months. If still nothing is made within 12 months and now it's the new year already and still no claim has come in, does the insurer pay still to the nominee? Since there's already a nomination form, the insurer should just still pay to the nominee, or insurers should hold on to the money, or what should the insurers do? Close file. Then the money, how? Money, what do we do? Insurers cannot hold that 1 million in the floating account, or do they go to the unclaimed money? What do they do? Unclaimed money. Unclaimed money. Okay, most people say unclaimed money. I would have guessed so as well, but unfortunately, the FSA says if there is still no claim made within 12 months, insurers have to treat the policy as if there is no nomination. So it doesn't immediately go to the unclaimed money, but we have to deal with it as if there is no nomination made under the policy. Okay, later on we'll look at cases where there is no nomination. Then how does the insurer deal with the policy monies lah? So this is what is provided under the FSA. So it doesn't automatically or immediately goes to unclaimed money. It is actually to be treated as if no nomination has happened. All right. Okay. Okay. Someone asked a question that if no one made the claim, how would insurers know about the death? In very rare situations, sometimes insurers, maybe there's a few policies and claim has been made under a few policies, but not this policy, and the nominees are different. Or various situations, maybe they have a medical claim, maybe they have a life policy, or whatever it is, somehow insurers got to know about it lah. Okay, so this is, like you said, rare situations. Usually insurers will not know until and unless a claim has been made by the nominee or the family. Okay, right. Now, where there is a nominee, if the nominee is the spouse and child, so now we're talking about the statutory trust. I mean, I'm sure most of you are very familiar with this concept already. So where a policy is purchased and there is a nomination done, and the nominee is either the spouse or the child of the policy owner, what will happen is that a trust will be created automatically, and this one is by law. It will be automatically created upon the death of the policy owner in favor of nominee. What does in favor of nominee mean? It just means that it is meant, the trust is created and the trust will protect the interests of the nominee, which in this case will be the spouse or the child. Okay, right. So what if the insured at that time does not have spouse or child living at the time of nomination? That means they don't have any living spouse or any living child at the time of nomination, and they nominate their parent. So someone who doesn't have a spouse or any child, and he goes on to nominate the parent, what will happen is that a trust will also be automatically created by the force of law in favor of the parent. Okay, this one very straightforward. So if there is no spouse, no parent, no child, anybody else that is nominated, is there a trust created for them? That means, can they take the money as their own money? Yeah, no. Someone said no, no. Yep, very good, very good. Yes, no trust will be created automatically. Okay, they will receive the money as executor in that sense. And if your customer wants to nominate a non-spouse, non-parent, non-child, and they want this person to receive the money as beneficiary. What it means by beneficiary means that once they receive the money, they can do whatever they want to the money. They don't need to give a cent to the family. If they want that situation, they must make sure that they do an assignment.
Mami kipon po.
Okay, all right. So you must remind your customer, if they want that kind of arrangement, they need to do more than just a nomination. They need to do an assignment, right? And a small note at the bottom, this whole arrangement doesn't apply to Muslim. Muslim have their own system and arrangement, different legal system. Okay, right. So now I'm going to move on to another question, another scenario, and I think this is quite interesting. So if we have a son who's the policy owner, and he actually nominates his father or mother. So a son, he nominates, in the ordinary situation, he nominates his father or mother. Then if something happens to him, the insurance company will pay the money to his father or mother as beneficiary. Because as what we've seen earlier, if there's no surviving spouse or child, then nominate the parents will take the money as beneficiary. Right. So now the question is this. What if in this situation, the son is the policy owner, he got married, and then he nominates his father under the policy? So it's a situation where he got married first, then he nominates the father under someone's sharing screen. Sorry, someone has accidentally set screen on their WhatsApp. Oh.
Sorry, using, can you share again your screen? Yeah.
No problem, no
Yeah,
problem.
thank you very much. Yeah. Yeah.
Okay, come, let me see. Can do this. Are you seeing?
Not full. Okay, good. Yeah. Now we can see the full screen. Thank you very much.
Okay. All right. Good. Okay. So this is a question. If the person is single or single or no surviving spouse or no surviving children, and the person goes on to nominate the father under the policy, we will just pay the father. Okay. But what if in this case actually the person married already, then went and bought a policy and nominated the father under the policy? So this is a real case where this happened. The wife and the father now fighting. So insurers have paid the father because the father is a nominee. But the wife is now coming to challenge and say that, look, yes, you can pay the father. Insurers are not wrong. They are not suing the insurer in this case. So the wife sued the father. The wife sued the father and say, you have now received the money as a nominee, but because I'm alive, I'm around. Okay, because when the nomination was done, there's a wife lah, there's a spouse alive. So when you nominate the father is only a trustee. He cannot take the money and pay for his Mercedes or his Ferrari. He cannot. He must take the money and distribute it according to the will. Okay, so that's what the wife said. The father is saying is that no such thing. I am the nominee. The law says that if I'm the nominee and I'm the father, so once the death happened, a trust is created in my favor, means I take the money and I can do whatever I want with the money. Okay, so now I think this is a very interesting case and scenario. So I just want you all to just put in your answers in the chat and let's see, what do you think? Who thinks, should we go to the father? Father can use the money totally, or the wife is actually entitled to the money? Oh, okay, very interesting. A lot of you think that the wife is correct and the father can only use the money as a trustee. Yes, yes, absolutely so. So this is wife entitled. Yes, yes, absolutely right. Everybody is very, very familiar with this. Yes. So the answer is correct. Father is acting as a trustee only. He cannot use the money. If he had used the money, he has to repay the money. Okay, so the basis or the provision under the FSA is actually here, where it says that the trust will only be created in favor of the parents if there is no spouse or child living at the time of nomination. So this scenario, if the son had bought a policy and nominated the father before he got married, the situation would have been completely different. Because he got married first, then nominate his father, that's why the father is now only as a trustee. Okay, so very fine line difference. A lot of lay people would never know about this. So it would be important for you to explain this to your customers and really find out the customer situation. So yes, in this case, the court directed the father not to pay to the wife, but to he cannot use the money for his own. He will need to distribute the money according to the beneficiary under the will or under the estate. Okay, so if the father is also a beneficiary under the estate, he will still get one portion, but he will not get 100%. Okay, so the difference between beneficiary and executor or trustee is that beneficiary, once you get the money, you can use it for anything you want. iPhone, you want to buy 4D number, you want to buy Bitcoin, doesn't matter, up to you. Nobody will ask you to be accountable for it. Okay. But if anyone receive money in the capacity as a trustee or an executor, they cannot do as they wish. They must follow the will or the LA, whatever terms are there. You are just an administrator of the estate. Okay, right. Okay, so what will happen in terms of payment of policy money if there is no nomination? Okay, if there is no lawful executor or administrator, insurer may pay to spouse, child, or parent according to Section 6 of the Distribution Act. Okay, so policy money, if there's no nomination, policy money has to be paid to the lawful executor or administrator. I think this all of you know. And how do we know who is the lawful executor or administrator? We look at whether there's a grant of probate, a letter of administration. In that court document, it will be very clearly specified who is the executor and who is the administrator. Okay, so if there is no lawful executor administrator, technically insurers don't have to pay out anything because it's dangerous. It's dangerous for them to do that. The grant of probate and the letter of administration would be the very concrete proof of who to pay to, because the last thing we want is for insurers to pay the wrong person. So in this case, if there is no lawful executor or administrator, but it is a very small family unit, there's no surviving parent, there is no kids, it's just one wife or one husband, right? And no one else is there. We don't think, and this agent is very familiar with this insured. There is no other surviving family, only one family member. The insurers can choose. So I've highlighted the word may, meaning that can choose to pay the spouse or child or parent, according to the Distribution Act. So Distribution Act is something that KB will cover later. So insurers in this situation, if insurers choose to pay without grant of probate or LA, then they will have to take up this responsibility to make sure they pay according to this Section 6 of the Distribution Act 1958. If the policy is less than 100,000, insurers can pay without grant of probate or LA if satisfied that the claimant is entitled to the property. So my question and my concern as GE's lawyer is that how would a claimant prove that he's entitled to the property without grant of probate and LA? Because to us, grant of probate and LA will be the most conclusive document out there. If insurers have paid the grant of probate, and then later on someone else from the family, some great-grandfather or great-grandchild comes from overseas and suddenly challenge the probate, right? Insurance company would not be in trouble because they paid on the strength of court document. But let's say now there is no court document and then insurers go ahead to pay. They have to be satisfied first that this person who's claiming is actually the rightful claimant and is entitled to the property. So how can a person do that? The person can show a will, okay? Show a copy of the will, or he can say that, look, this person died without will, insured died without will. I am the only wife and my 2 children, and the father has already signed some documents to say they don't want any money from under the policy. So looks like I'm the only one available. So if insurers are satisfied with this kind of documents, they can. The law allows them to pay the policy monies to this person who they think is the rightful claimant. But in situations like this, insurers must make sure that any signed documents, originals are there, properly witnessed, because we know forged documents is a problem as well. So all these documents have to be done properly. As an agent, perhaps you would have to definitely personally witness the signing of these documents before submission to the insurers. And then if the insurers are satisfied, they can actually pay it out if the policy is below 100,000. Right. Now, we come to the issue of assignment. Assignment is different from nomination. Just now we've gone through it already. Assignee actually has priority over nominee. What this means is that assignee will get paid first. Okay? Right. Assignee, so the priority, the pecking order is assignee first, then nominee. So the question here is, if 80% of the policy monies have been assigned to A, and policy owner also made a nomination in favor of B, sum insured is 100,000. How will the policy monies be paid? So this 100,000 goes to who? Let's invite some answers on the chat. A lot of you say assignee, but then 100,000, how much go to 100,000? All go to A. Okay, we have a lot of answers. A, 100,000 to nominee. Some say A, some Low says 80,000 to A, Lim says 80,000 to A. A will receive 100,000, some will say A, okay, 80-20. Someone said that. Someone said A. Okay, all right. Someone said GE does not practice partial assignment. Okay, I don't know the practice of GE, but this is in the event you have this situation. Okay, so if GE doesn't practice that, then you don't have this problem. Right, in the event there is such a partial assignment, then 80,000 actually goes to A, the balance 20,000 goes to B. So the assignment is only for 80%, so the assignee only gets 80%, cannot get 100%. Then the balance, because the nomination is still valid, we're not saying the nomination is not valid. It's just that take second round, take the second whatever's left. Okay, so if you have this situation, 80,000 will first be paid to A as the assignee, and then the balance 20,000 will go to B. So now we have the second scenario is a total complete assignment, right? If 100% of policy money is actually assigned to A, and then there is a nomination made in favor of B, then now how? 100,000 sum insured again. How does the insurer pay under this policy? 100% to A. Someone said 100% to A, yes. Leong said that. Okay, yes. So the answer is 100% to A, 100,000, yes. 100,000 to A and nothing to B. Okay. Someone asked the question, can an assignment and nomination coexist? Again, this is just my personal view. There is no issues of them coexisting. It's a matter of priority of payment. So as you can see here, if it is a partial assignment, the nomination is actually worth something. It's worth 20,000. It's not completely void. But in the situation where you have a complete assignment, basically there's nothing payable to the nominee. It doesn't void the nomination. Legally speaking, the nomination is not void. It's just nothing payable to the nominee because of the assignment. Okay, it's as opposed to a nomination that is done not properly done, then the nomination is void, right? In this case, I don't think that it's void. I think it's just a matter of priority of payment, who gets paid first. And if you're last and nothing left to pay paid under the policy, then you don't get any payment. Okay. Okay, so here we have a bit more facts for you. If sum insured is 100,000, 1st of January 2020, policy or the insured actually nominated N as the nominee. 15th of January, there is a security executed in favor of A for 60,000. And then 2 months later, there's another security executed in favor of B for 55,000. So in the event of death, later part of the year, how is payment to be made? Okay, I take note that GE doesn't allow for partial assignment. Just treat this as a trivia that you can do. Okay, and just think about how would GE have to pay, or how would any insurers would have to pay in this situation? How would the 100,000 be paid and paid to who? A or B or N? And how much to each of them? Right, we just wait for a while for the answers to trickle in. Hey, no answers this time. Cannot be. You guys were doing so well. Okay, someone said pay to N 100%. But remember, assignee will take priority over nominee. How do we do this? Oh, first, technically it's wrong. The total has more than 100. Okay. Okay, that's a good point. Okay, let me reveal the answer. Balance. Okay, someone said 55K to B and then balance to N. Hey, what about A? A 60,000, B 40,000. Okay, Leong says that, and then A to B 55, A 60, B 40. A gets 60, B gets 40. Okay, right. Thanks for that. Thanks for participating. Okay, answer is this. A gets 60, B gets 40. Right? Most of you got it right. Nothing to N. And the reason is what some of you mentioned. Because the security executed is actually more than the sum insured. It is possible because security executed, the security is actually a separate arrangement from your policy. It's not guided by your policy. It's whether the insured owes someone money and then they want to use the policy as a security. So it's too bad for B, for example, because his security comes second in time. His security came second in time. That's why he can only take the balance, even though it's not enough to satisfy his debt of 55,000. Because there's only 40,000 left, so you take the 40,000. So the security executed first in time has first priority over the second security and the third security before the nominee gets a chance to claim the money. Okay, so in this case, if the B security is only 20,000, then N will get the balance. Okay, right. So here, the next question is a bit of a tricky one. So just now I said that A security was executed first in time and B security later. That's why A takes the money first. But what if this security was executed by the insured on his own? This security thing doesn't involve insurers. It's the insured going to arrange on their own. What if he has done all that and he doesn't inform the insurers? Because if you don't inform the insurers wouldn't know and they wouldn't be able to guess that you actually have a security or an assignment in place. Okay, so here, where you have a customer who has all the security done, you must remind them to make sure that a written notification is made to the insurers about this kind of arrangement. Then only the scenario on top will happen. Okay, so for the sake of discussion, A was executed first in time, but the insured only informed the insurers later. So the insured went to insurance company and tell them about security B first, then only they told the insurance company about security A. Okay, so that changes anything or not? So security A was executed first, but insurance company only know about it later. So do we follow the notification date to the insurer, or do we follow the execution date of the security? What do you think? So is it still the same situation as the first situation, 60K to A, balance 40 to B, or we change? Okay, some say follow execution date, Can we see what other answers there are? Okay, someone say 55,000 to B. Okay, that means changes lah. We follow the notification date. Okay, so the case Lee said 60K to A and 40K. Okay, right? We forgot about B. There's a security A, B, and then nomination N. Right. So this changes everything because we follow the notification date to the insurers. As I said, securities and all these are executed by the insured separately and independently from the insurance company. Insurance company cannot know. So until and unless written notification has been properly made to the insurers, then they can record it in their system, then it takes effect. So if the notification of the security was made differently, it changes the whole payment arrangement already. Okay, so again, another thing, important thing for you to remind the customers, because a lot of times customers go and do all this arrangement, they don't even tell you. So by the time you know about it, it will be too late already. So it might be good to inform them upfront that in the event you do this in the future, during the policy currency, you decide to do this, you decide to do that, please let us know. Please make sure we inform the insurance company. Okay, all right. Okay, next I have a case study. Okay, this is the time that if you have pen and paper, take it out and do some writing. Sorry, I have an annotation request. I don't understand what it is. Alex, can you help me? It's asking me to approve or decline. Someone is asking to annotate the shared content. Alex?
You just have to actually
Should I approve or decline?
Decline. Sorry.
Okay. Sorry, I'm very new with
Yeah, it's fine. It's fine. Yeah, sometimes it's accidentally
too chunky
appear.
already.
Yeah. All
Okay.
right.
All right.
Okay.
Okay. Someone wanted to know what security, trust, assignment, all this. KB will be able to take you through it later. Right? Okay. So I'm dealing with the insurance aspect. I don't want to give you the wrong information. So KB, note that you need to answer this question later. Okay. So now this is a case study. Okay. You have an insured who is a very loyal supporter. He has bought 5 policies with you. So that's first policy, I put it as certificate lah, but it's first policy, 250,000, and the insured actually nominated the spouse. And then for the second policy, 300,000, nominated 2 best friends as nominee. And then third policy, 300,000, nominated 4 other relatives, A, B, C, and D, but D predeceased the insured. Policy 4, 200,000, no nomination. The 5th certificate also no nomination. The insurer got fed up already lah. Don't know who else to nominate, so he just bought the policy and left it as it is. Okay. Then of course, unfortunately, the insured passes away. How would not you, but how would the insurers make payment in this kind of situation? So it's more of a nomination question. And remember just now we went through if it's a spouse, what would happen if the insured dies? If the nominee is not a spouse, not a parent, not a child, what actually happens to the nominee? And what if a nominee passes away before insured? So this case, like policy 3, actually one of the nominee predeceased only, not all. So what will happen? Essentially assume that now the insured has passed away. Who will get payment and how much under each policy. So maybe we give you 1 minute or 2 minutes to just work this out on your pen and paper and then type it out in the chat. Okay, and give me a bit of time to drink water. Okay, all right, I'll come back to you in 1 or 2 minutes time, and then as and when you have the answer, just type it on the chat. All right, thank you.
Sorry, Izin, your mic is muted.
Oh yeah, sorry. Thanks. Sorry, someone asked. Thank you so much. Someone asked whether it's possible to nominate best friend because best friend doesn't have insurable interest. So actually you can nominate anybody. You can nominate. The law allows you to nominate anybody because the nominee is just the person who is supposed to receive the money. It's not the insured, not the life assured. So that's not an issue. It's just that what is different is the capacity in which they receive the money. So whether they receive the money as a beneficiary or executor and trustee, as what we discussed earlier. Oh, we've got very, very good participation. Very good. A lot of scenarios. And then to pay according, okay. Right. Let's see. What? Certificate 1, certificate 2. So that's one. Very diligent and responsive agents you have. I am very, very pleased. Okay. All right. Very good. Very good. Thank you very much. Still have answers coming in. 4 and 5, money goes to spouse. Spouse 250, friend. Okay. Good. okay. Someone said certificate 1 pay to wife, certificate 2 to the 2 friends, certificate 3 to 3 surviving relatives as executor, certificate 4 and 5 to GP. Who's GP? Run of probate, is it? Okay, got it. Thank you very much. Yes, okay. So yes, okay, right. So basically what will happen is, if you have the answer, then you just check it against your answer. Certificate 1, 250,000 to the spouse. Absolutely correct. That's very straightforward. Certificate 2, which is policy 2, they will be paid, the best friend will be paid 150,000 each. And as a lot of you have correctly pointed out, they will receive the money as executor, not that they can go and buy their own. I want to say Lamborghini, but I think 100,000 cannot buy Lamborghini lah. So they cannot buy their own things. They have to still go back to the family and say, look, do you have a will? Did he have a will? Did any of your family members went to court to get a letter of administration? If they did, then I have to take this money and distribute it accordingly. Okay, right. So customers will come to you and say, I want to nominate my best friend, because my family don't care about me. My best friend is the one taking care of me. So I want to nominate him or her and make sure him or her gets the money. Remind them that they need to do something more than just nomination. Otherwise, the money still will not go to them. It will still go to the family that he didn't want it that way in the first place. So very, very important to make sure your customer understands about this, right? Okay, so when it comes to policy 3, so we have 4 nominees, A, B, C, and D. D pre-deceased already. So at the time of death of the insured, what will happen is that, because your policy is 300,000, right? So you divide by 4 first, because got 4 nominees. So 75,000 each goes to A, B, and C. Okay, and then D's portion will be shared among A, B, C. So essentially, what A will get is 75,000 plus 25,000 from D's portion. So A, B, and C each will get 100,000. Well, you all work out the maths very quickly. Just now I remember a few answers there. I've already said 100,000 to A, B, and C each. Okay, right. So that's very clear. Policy 4. Policy 4, we don't have nomination, but it's above 100,000. So policy 5 has no nomination, but it's below 100,000. So what's the difference here is that, remember, insurers can choose to pay to people who, to families who don't have the grant of probate or LA, but if it's above 100,000 and below 100,000, then there's a difference in payment, right? Okay, so here, whatever it is, it has to go to, first of all, for policy 4 and 5, it has to go to the persons who has the grant of probate or letter of administration. That's for sure. That means it goes to the estate. Okay. In the event there's no grant of probate or LA, then insurers can choose not to pay at all. And as GE's lawyer, that's always my recommendation. Legally, it is the safest position to take. It may not be realistic in certain situations, but we have to consider that on a case-to-case basis. But please understand that in the event there's no grant of probate and then there's no LA, and insurers decide to pay to, let's say they think that, look, this guy only has one wife, right? No family, no other parent. I know him for 10, 20 years already. He has no other people. He only has his wife. The wife now is coming to claim, right? He's the only, the wife doesn't work. She's a housewife. She has no kids to rely on. Now she needs the insurance money. Please pay, even though she doesn't have a grant of probate, right? Although it may seem very logical or reasonable sometimes, we have had situations where monies have been paid to the wife, and then from nowhere you have someone from China saying that I'm actually his wife in China. He has actually given me a will, right? And I'm supposed to receive all this money. So what will happen is that insurance will get sued, and then there'll be a question about whether they paid the money correctly or not. But if we rewind, this entire scenario comes out and there is a grant of probate, and insurers pay to the executor that is named in the court document. and then some girlfriend, boyfriend all come out from the woodworks a few years later, they should then, okay, if they then want to sue, they should then sue the people who receive the money. They should not touch the insurers, because insurers follow a court order. You can't question the court order lah, unless it's been forged lah. But this one, don't complicate matters. So assuming there's a valid court order, insurers paid on it, that is the safest route in terms of legal liability is concerned. Because the worst thing you want is that insurers pay the money to the wife, and then she uses it to pay for the house, this and that already, and then later someone else comes in to challenge, and then the court directs her to pay back the money. So the court decides that the money paid out wrongly already. Then this poor lady would have spent the money already, and now she would have to then find ways to get back this 100,000, 200,000 to pay back. So it's not a very nice situation to have lah. So that is the situation of why, or that is the explanation of why grant of probate and LAs are very, very important. And at times I do have insurers who ask that, you know, grant of probate and LA, it requires some money. But sometimes if the person has quite a bit of assets, or if the policy amount is quite big, it does raise questions as to why the family refused to go to apply for grant of probate. Because once you go to the court, there's some procedures and steps that you need to satisfy. Okay, so if they don't satisfy that, they can't get the court order, which is the grant of probate or LA. So I have come across a situation where the family refused to go to the court to apply for grant of probate because they know that the insured has another family. So that's why they refuse to go to court, because they know if they go to court, they have to alert this other family that he has a policy of 1 million or 300,000. So sometimes we don't know the full facts, or they don't tell us the full facts lah. So that's why these steps are, or these preventions, or these procedures are in place. The law has set out lah. So you pay on grant of probate. If you don't want, then this is the situation, and that's why there is the 100,000 kind of cap. 100,000, any policy below 100,000, insurers without grant of probate or LA, they can pay to the person they think is entitled to. So in the scenario that I just explained to you, they can still pay to the wife. So policy 5, they can still pay to the wife, not a problem. Policy 4, they can still pay to the wife 100,000. The balance 100,000, they still need to wait for grant of probate. So even the parliament, when they set out this FSA, they are also scared. If there's no grant of probate, they also feel a bit insecure about making or forcing the insurers to pay when there's no such court document. That's why they have put such a cap back. That's my view. That is 100,000. Okay, sometimes the policy is small. It's not worth it for the family to go to the court to spend money, legal fees to get a court document. So they provide for this kind of alternative arrangement, where if insurers are satisfied with the documents that they are paying the rightful claimant, then they can still make that payment. Okay, all right. So we have that. And next up, I just have a very weird question for all of you. What if there is a grant of probate, but this grant of probate is obtained in Japan or America? And then your nominee comes to you and say, I got a grant of probate, but because I'm a Japanese citizen, so it's in from the Japanese court. Is that possible? Would our court recognize it? Sorry. Yes. No. Okay. Actually, this is a trick question lah. Yes and no also correct, because yes, the court on its own, the Japanese court document will not be automatically recognized by our court. So what they will do is, well, what the nominee has to do is, what the executor will have to do is to take this court document from the Japan courts to go to our court to certify the copy, and then they need to register the Japanese court order with our Malaysian court, and then the court will have to seal. Seal basically means they need to stamp it lah. Exactly. So Affinity Life Services need to reseal it in Malaysia. Yes. So that's exactly the procedure to have to go through. Then once they have done all these things, then that Malaysian court document is submitted to the insurers. That will be recognized. So that's why I say it's a trick question. Yes or no also correct, depending on whether they've gone through this procedure. Okay, so what if, what if after the insurers pay, C actually, or they apply, like someone else actually applies to the Malaysian court to set aside a Japanese court order. So this is a situation where someone comes in with a Japanese probate. They go to the Malaysian court, get it registered, sealed, and everything already, then submit to insurers. Insurers paid the full policy amount to this person already, say A, paid to A already. And then after pay, C comes to Malaysian court and say, hey, the Japanese court order is not in order. It should be payable to me instead. So what will happen? What will be the insurer's response? Insurers will simply say, we have already discharged our liability because I have acted in accordance with the FSA. So if want to fight, A and C, two of you fight in the Malaysian court, but don't involve me because I no longer have the money and I've totally discharged my liability under the FSA. So if you want to fight, both of you fight together. Okay, what about Commonwealth country? Commonwealth country, you have a reciprocal enforcement of judgment act. So that one, there's a list of certain countries that we recognize, and their court recognize our act as well. So that one is a different situation, but you need to fulfill and fall within that list. Okay, right. Next question is this: what if the insured is a Muslim? So what happens? So in this unique situation, the policy owner doesn't prefer a takaful certificate, just wants to come and buy a conventional insurance policy. So can the insured make a nomination? If the insured is Muslim, he wants to make a nomination, can he make it? Fan says follow Faraid. Leong says can. Okay, based on my past experience, after the first two, there will be a gap, and then suddenly there will be a lot of answers. So let me just wait for a while. Lo says nominee receives money as executor. Then there's another answer says can. Okay, all right. Cannot for conventional policies. Okay, actually, all of you are right in a way. Okay, if you look at strictly FSA, FSA doesn't prohibit nomination for Muslims. Okay, just now one of the slides, remember I put a small note at the bottom to say, note, this does not apply to Muslims. That one is where the creation of statutory trust. So the provision that allows nomination to be made under FSA, it doesn't prohibit Muslims from doing it. Okay, so that's the first fact you need to understand. Muslims can make nomination. But for the nominee to receive the money as beneficiary, they need to then go to make a conditional hibah. Okay, conditional hibah means a lifetime gift. They need to do this extra step to make sure the nominee receives it as a beneficiary. Otherwise, as you all have said, executor, you follow Faraid, you follow their Islamic distribution method. Okay, so if you have a Muslim customer, you need to explain that they need to make it a conditional hibah. How to make it, I am not sure because I'm not Islamic law legally trained, but they would have to see a Sharia lawyer to see how to make it happen. So if you look at the IFSA, IFSA, whenever a nomination is made under a takaful certificate, the participant need to make a choice whether to do the nomination and have the nominee receive the money as an executor or as a beneficiary. So if there's a beneficiary choice is chosen, then the nominee receives it, and that's as if a conditional hibah has been made. So it's possible to come out from the Faraid, to come out from the usual estate distribution for Muslim, but they need to do an extra step, which is to make a conditional hibah. Okay, conditional hibah is a lifetime gift, so meaning that you give it away already, so it will not form part of your estate. Okay. Right, very good. Next question, what if the nomination is not witnessed? Yeah, this one very easy lah. I think I won't trouble you guys. So if it's not witnessed, if it's not in order, if the full name is not there, you know, the names are not complete, we don't have the IC number and all these things, then yes, someone said it will be void. Actually, insurers will reject the nomination. So better that you check first when you first receive it. You check first. If it's not in order, it's not properly witnessed, don't submit it. Get your clients or get your customers to properly complete it first before you submit it lah. Because if things fall through the crack and then when they need it later to be distributed accordingly, then that's where the problem arises. Then it will not be as pleasant already. Okay, so I am done with my part. Thank you all very, very much for participating. I know there are a lot more questions put in the chat. I think some of it, I didn't have the time to finish reading it, but some of it also may relate to what KB is going to present later. So what I will do is that we'll put a pin on it, and then we let KB present his part and then see whether you still want those questions answered. Okay, all right. Alex, do I pass back to you or to KB directly?
You can pass to KB directly. Yeah.
Okay, KB, are you ready?
Thank you, Alex and Sizin.
Okay, thank you.
Very, very interesting presentation. I should ask my corporate lawyer to join. All right.
Thank you.
Probably
Thank you,
you can take
everyone.
a break and I'll continue.
Thank you very
Just
much.
give me 1 second. All right. The good news is seasons have already covered quite substantially. I probably can reduce my task for today for quite a number of slides. Okay. Well, she's preparing the slide from the what do you call it, litigation angle, definitely. And from my end, I'll look at it from a corporate perspective. After all, I'm just a corporate lawyer sitting in office drafting documents. Okay. Introduction. I mean, most of the concept over here, you're probably quite familiar with it. So again, like what Cezanne say, it's just a refresher. And please let me know if you have any questions. Okay. I want to go. Okay. The first questions that actually GE raised to us is a wider aspect of the estate planning. Give me 1 second. Alex, there is a
Yes.
message to ask for a short break. Should we just take a 5-minute break for the what do you call it, audience?
Yeah, I think we take is it okay to take 10-minute short breaks? Just
By all means, by all means.
Yeah, then we shall continue or resume at 10 or 40. That's
Yes,
10:30, yeah.
for sure.
All right, yeah, cool.
No problem.
Hello? Xizing, are you there?
Yes, Jason.
Xizing, are you there?
Yes, yes,
Thank you. Xizing, let me give
yes.
you a little feedback. Thank you so much for your training. Excellent, so clear. We
Thank you so much.
we are
Very kind of you,
benefiting
Mr. Nga.
greatly from your training.
Great, great. Thank you so much. Very
Yeah,
nice of you to let me know.
Truly appreciate your training. You're very knowledgeable and it's so clear. Your voice is so pleasant and you are also so pleasant yourself. Yeah, wonderful.
You are
It's
the
truly
sweetest,
wonderful. We love your training and we truly
Great,
appreciate.
great to hear that. Great to hear that. I'm very happy actually because all of you are very participative. So that makes a difference. Otherwise, I'll be staring and talking to my own monitor.
But the way you conduct your training, participants like to participate.
Thank you. So it's both ways.
Never a dull moment, in your training, Xizing.
Thank you very much. Thank you
Excellent.
very much.
I talk from the bottom of my heart.
Appreciate it.
Yeah, let me ask you one question,
Yes.
Xizing. For creditor proof, an insurance policy, when it is absolutely assigned, is there a certain period or not
Sorry, a certain period
for it to be creditor proof?
creditor proof. I don't quite get it. What do you
In
mean
other
by
words, let's say a life insurance policy, and
Mhm.
this policy, the insured as policy owner assign it to another person or another party.
Okay.
But then he owes money, creditor come to claim. Is there a certain period or not for it to be creditor proof?
Okay. So, creditor proof, I suppose what you mean is that after a certain period, then creditors cannot come back and challenge it
Yes,
to
correct.
fight for the money anymore. Yes, okay. It really depends. If the policy is meant to defraud creditors, then I think under the Insolvency Act, there is a 2-year and a 5-year period. Within 2 years, it's an absolute void. Within 5 years, they can come and challenge, but subject to proof. So I suppose to give you a very easy answer is that anything above 5 years will be quite safe.
Okay. All right.
But it doesn't mean if it's within less than 5 years, then it's creditors can come, you see, because ultimately they still need to prove that the policy was entered into with the intention to defraud creditors. But
I
if it's
see.
just personal intention to protect your family, protect your estate, that shouldn't be challenged.
Thank you so much, Xizing, for the bonus.
Good morning. Can I ask a question?
Oh yeah, okay, sorry. Who's this?
Wong Fun here.
Wong, okay, Mr. Wong, maybe we hold it for a while because I'm just worried the rest are not here. They may not be able to benefit from your question.
Okay.
Sorry,
Okay.
thanks. I appreciate it.
Thank you.
And thanks, Mr. Nga.
Thank
We
you
take
so
the break
much,
first and
Xizing.
then we wait for
Yeah,
the
sure.
rest to resume first. Huh?
Thank
Okay,
you.
thank you.
Thank you. Bye.
of estate planning. Since Citizens have already covered quite a bit of the nomination part, probably I can focus more on the will and the trust issue that I will address it later. First of all, what is estate planning? And estate planning is getting common nowadays, be it in Malaysia or Singapore. The so-called high net worth client, they start with all sort of estate planning, so-called plan, and they've actually consulted the lawyer to structure for them. So as a general rule, or rather as a layman understanding, is that basically it's a process of establishing the wishes and intention for management and distribution of an asset, and normally we refer to the family asset after the death of the current owner of those assets. And there are plenty of ways of doing it. But first of all, this estate, or rather the asset within this estate, normally include all the immovable and movable properties. It could be land, house, condominium, or whatnot. Movable property, it could be as wide as a cash, share, saving account, your EPF, your insurance, your car, even your furniture. So all these considered as part of the estate. But the problem is always, how are you going to distribute it after you pass away? Or even before you pass away, can you distribute it? Estate planning, you can distribute it, and the main reason you need to plan early, especially your customer who happen to be a high net worth customer, you need to let them know that they all should plan it early. The whole idea is to protect their personal wishes. They may have their own plan among the family member. I like person A, I dislike individual B. They have to plan it, and there are many ways of planning it. Is at least we can think of 5 ways, or rather 4 ways actually. Will and wasiat, of course, depending on whether you're Muslim or non-Muslim. Trust, power of attorney, and nomination, which you all have actually quite familiar with it. I'm going through each of these, legal instrument one by one. Just bear with me. Sorry, there's no Q&A for my slide. Just bear with me and try to understand. Let me know if you have any queries. First instrument here, we are talking about will. Will in simple term, basically we are talking about an instrument by which a person, allow me to complete the sentence, arrange for the distribution of their property to take effect after their death, and which its own nature is ambulatory and revocable. What it means actually is that your will, you can create it anytime. Create, recreate, draft, redraft, amend, re-amend, but it will only crystallize upon the death of the testator. Testator meaning the person who write the will. After you pass away, then only your will be effective. Why we call it as an ambulatory is because it will have no legal effect until you pass away. And we call it revocable is that you can amend it anytime you want, as many times as you wish, until the last minute of, until you die, basically. So in Malaysia, we actually, our will is actually governed by Wills Act 1959. You look at the year of the act, you know this is a very old act. It's post-Merdeka Act. Meaning, we actually adopt quite a number of principles from the UK or the English legal system. They define section 2.1, they say, is a declaration intended to have legal effect of the intention of the testator with respect to their property, and it can be done by way of testament, codicil, and will. These are actually just a legal jargon to me. Basically, to me, I will just advise your customer, prepare a will. If you want to change it, you can change it anytime with a fresh will. No need to prepare a codicil to make things simple. Prepare a new will because the latest will take effect. The old will, if you have actually dated earlier than the latest one, it will be deemed not effective anymore. In fact, I would just tell my client, you can just tear it, burn it, throw it, just keep one will in your safekeeping. Wasiat, similarly, this is only for the Muslim. And in Malaysia, Islamic law is actually different for every state. That's why we can't actually tabulate all the enactment for all the state, and we choose only Selangor. The Muslim will, Selangor Enactment 1999, more or less they say the same thing like will. Basically, this is a way for you to actually put down your your intention, how you want to distribute your asset. But there are some main rules for you to prepare a will. If I may go back to the previous slide. First thing, testator, meaning the one who prepared the will, the one actually, or rather the owner of the will, you must be at least 18 years old. Second, you must be of sound mind. You must know what you are doing. The will must be in writing. The will must be signed by the testator at the foot or at the end of the document. They need to sign it, and they need to sign before two witnesses. The witnesses must not be the beneficiary. So I saw questions in the chat box you asked whether a person can prepare their own will and sign before two witnesses. The answer is yes. You can draft your own will. Today I wake up, I want to draft a new will for myself. You can do it so long as you do it properly and before two witnesses. But I would not encourage anyone to prepare the will by themselves simply because the will is actually rather, I wouldn't say complicated. In fact, if you actually use a ChatGPT or Google, you'll find plenty of template there. But are they actually good will? From my experience, most of the time, no. The will should not be a set of template for you to populate data. If you want to do a proper will, please make sure to engage someone with decent knowledge on the succession law and customize it accordingly. That's my advice to you as well as your customer. Okay, we are not going into details how to prepare the will. Today's topic is not successions. So the next instrument, trust. The difference between trust and will is that for will, it will only crystallize upon the testator death. But for trust, it will crystallize with immediate effect upon the creation of trust. There are a number of type of trust here. We include express trust, implied trust, constructive trust, and blah, 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 blah. Your main concern, or rather your customer concern, mainly is on the express trust. How trust work is that, let's say if I have a house, today I wake up, I say, okay, I love my girlfriend very much. I hereby declare the house as a trust property in favor of my girlfriend, and I myself will be a trustee. The moment a trust is being declared, or rather put in writing via a deed of trust, I am no longer the beneficial owner of the property. If I pass away, this house will not be part of my estate. It will be considered as belong to my girlfriend, and she just need to perfect the transfer of the ownership, the title deed, change my name to her name. So, in other words, the moment you create a trust, you are technically no longer the beneficial owner of that property, and that's it. You already give it away to the beneficiaries. So this is something that you need to be very careful when you create a trust. It cannot be changed anymore. Another instrument is also quite common. We call it a power of attorney. It is actually a formal instrument where one person actually appoint another person to represent him to do whatever purpose stated in the document. My power attorney is just probably a 3 pages long or 5 pages long document. Basically, imagine I have a power attorney. I say, I hereby appoint Cezanne as my attorney. She can do everything related to my estate. So she can then, without further checking with me, sign all the relevant land office instrument and form for and on my behalf. And this power attorney, so long as it is not revoked, it will remain valid, and Cezanne's signature will remain valid as well. She will be my representative and do everything allowed within the 4 corners of the document. So there are some of our client will love to do this. Basically, they will create a power attorney to their son and expect the son to do son or daughter, of course, and expect their child to do everything on their behalf. So this is also a way for them to manage their the asset as well as the estate planning. I just want to go through in details on the concept of power attorney. Basically, this power attorney is a concept called principal and agent relationship between the donor meaning the person who give away the power, and the donee refer to the attorney. The attorney will then sign everything within the scope provided under the power of attorney. So there are four basic steps to validate a power of attorney. Is that first, of course, engage someone or you yourself can prepare the power of attorney, get it signed, get it authenticated, basically before a lawyer, before a judge, before a field officer, send it for stamping, and eventually register in the High Court of Malaya. The moment you have complete these four steps of validation, your power of attorney will be deemed valid, and your attorney can do whatever they want. So if you ask me, this is a very convenient mechanism, but it is also very dangerous. It's something that you all need to take note if you actually advise your customer to prepare a power attorney. It must be very, very careful when you exercise the power and you draft the power attorney. The fifth is nomination. I do not need to explain further. I think Citizens have covered it in quite details. So basically, these are the few instruments we can think of to help your customer to plan their do the estate planning. So for you to consider, but please take note, all these instruments subject to the respective rule as well as respective law. So if they want to do it by themselves, my advice to them is that, question to them is always, do you possess the the sufficient knowledge to prepare all this? If not, just engage any lawyer. It need not be us, any lawyer or anyone legally trained. Ask them to just have a look at it, prepare it to make sure that it will not create all other dispute in future. This is actually very, very common based on our experience.
KB, sorry, I saw you on the camera earlier, but now I can't seem to see you. I'm not sure if it's some problem with your camera.
I see. Is
There
it
you
better
go.
now? All right.
Yes, we can see you.
It's okay. Okay. If I may proceed with the next, why nomination as opposed to other methods? This is a question that I think Citizens somehow have covered it, and I'll just go through it a very quick way. Nomination can be done for these three types of instrument. One is EPF. Of course, it's not relevant to GE. Another Takaful as well as the insurance. So all these instruments are governed by different law. And because of this reason, they will not be, they will prevail over the will because they have specific act governing it. Okay. For EPF, who is eligible to make a nomination is for the EPF member above 18 years old, for Malaysian and permanent resident. For non-Malaysian, I'm so sorry, you are not allowed to make any nomination unless you are their member before 1st of August 1998. There is actually a regulations, Section 70D, Denmark, of the EPF Act actually says so. For insurance as well as Takaful, policy owner above 16 years old. And this one we have covered before. Basically, FSA and IFSA, they make it clear. 16. EPF is 18. Please see the distinction here. The effect of the nomination is that for Muslim, the nominee, is known as a wasi, and the role is to distribute the EPF member of saving according to the Islamic law. Here we are talking about the Faraid law. For non-Muslim, the nominee will just be the rightful beneficiary. You can just take the money and do whatever you wish. It's a bit different from insurance because for insurance and Takaful, next slide. Section 130 of FSA 2013 as well as Schedule 10 to make it very clear that as a nominee, you are not automatically entitled to the money. If you are spouse, child parents or whatnot, you are entitled to receive it as a beneficiary. But if you are none of these categories, you can only receive it as an executor. For GE, once you distribute the money to this nominee, you have discharged your duty. But the recipient, meaning the nominee, who is not the wife, not the husband, not the child, not the parents, you hold the money, but you cannot spend it. If any of these nominees actually spend it for their own personal benefit, this category of beneficiary, the rightful beneficiary, can take legal action against the nominee. Likewise for Takaful, but of course, you need to bear in mind that even though you are a nominee, you can or you may receive it as executor beneficiary according to the Sharia law as well. So for Muslim customer, I think you need to be very careful when you give them any advice, in the sense that be mindful and always check with the relevant Sharia lawyer about the way to distribute or to spend the money. So this is something that we always tell our client, please consult a Sharia lawyer on this matter. Okay, why you need nomination as compared to other methods? It's because nomination is always easy to set up and rather at no cost at all. I'm not sure about GE practice. You probably can just sign a form and just submit it to the agent, and agent will escalate it to the relevant department. Then you can create your, you can actually, nominate your preferred individual as your nominee. It's very straightforward, and I don't foresee any complication, and you can actually get it done very fast. Compared to other methods that we raised earlier, be it will or wasiat, it's a long process for probate. It will take about 3 to 6 months at least to actually get a grant of probate. Trust, you can create very fast, but if of course complex, and it depends on how complicated is your trust, it could be quite pricey sometimes. Power of attorney, you can do it as well, but like I say, it's a bit dangerous if you actually allow the power of attorney to be prepared without actually heavily scrutinize the content of it. It's a very dangerous instrument. I need to remind you all once, and really need to be very careful with the power of attorney. It's very popular questions from BG or from other clients. If you have a will, is nomination still required? I told you earlier, the answer is yes, you still need a nomination if you want to nominate someone. Of course, if you don't want to nominate someone, then you can let will to govern it. But we always remind our client, for EPF, insurance, takaful, please talk to the agent. Please ask for the nomination form and do the necessary. This is also a point for you to always remind your customer. If there is a will, why you still need nomination? Because for Muslim member with nomination, for EPF, it will go to the nominee as a personal representative. For non-Muslim, it will go the same thing. It will sorry, for clarification. For Muslim, EPF, if you have nomination, it go to the nominee as a personal representative, be it an executor or the administrator. If you do not have a nomination, you also need to go through the process of getting the court order, the sijil faraid. So this is a very complicated process and rather long because of the Sharia law requirement. For non-Muslim, things is a bit straightforward. If you have a nomination, your nominee will just get the money from the EPF fund. If you do not have the nomination made, the money, the fund will go to the residuary estate, unless you make it very clear in your will to say that if there's no nomination, money will be distributed or bequeathed to individual A or individual B. So this is for EPF. For insurance, takaful, they are rather similar but not identical. If there's a will, for nomination for insurance, of course, you pay to the nominee. But when I say pay to the nominee, bear in mind, it could be paid to the nominee as a personal representative or pay to the nominee as beneficiary. But if you do not have a nomination, always ask your customer to provide you with a grant of probate and letter of administration. Like what Citizen say, this is a way to protect GE. Just rule of thumb, always ask them to give you a copy of it. Can a will override a nomination? Answer is no. The moment you have made your nomination, whatever you put in the will it will not prevail over the nomination. The legal concept is that the moment you have nominated someone, this asset will be ring-fenced from your total estate. That's why even though you have a will and you make it very clear, you can put in the will to say that the nomination is no longer valid. It will not negate the fact that the nomination previously made will prevail. So on this part, if you are actually advising your customer to prepare a will, just ask them whether they have actually made nomination prior to the preparation of will. If the answer is yes, ask them to liaise with the respective agent to actually make their amendment via the proper process. Okay, this is my focus on the trust because it's getting more and more popular nowadays. What is a trust? It's an equitable, this is a definition from a textbook. Okay, just bear with me. A trust is an equitable obligation binding a person, a trustee, to deal with the property over which he has control. Trust property for the benefit of someone. The someone could be himself or someone else. Meaning, I use back the same example. I wake up one day, I suddenly, instead of being an owner, I plan to declare a trust. I call myself a trustee. And I plan to deal with my house, which I have control because I am still the owner on record, based on the land office record, based on the title deed, I'm still the owner. But I self-declare as a trust property. And then I say, my house, the trust property, will now be given to my girlfriend as a beneficiary. We have not formally changed our name on the title deed yet, but a trust has been declared. So a proper process is that I then prepare a trust deed. I will then present it or submit it to the land office. The land office will take note. They will actually take my original title deed. They will put at the corner there to say that KB Tay is now only a trustee. Hold the property for and on behalf of the beneficiary, Miss So-and-so. So this is how trust works. The moment I have actually completed this trust process, it will not be considered as part of my personal property anymore. If I pass away, even though I have a will, it will not be deemed as part of the estate. So basically, my family, I'm so sorry, you're just no longer entitled to the house anymore. So this is how a trust works. There are plenty of trust instrument out there, but of course, each of these trusts should be customized or tailor-made accordingly. We'll not go into details of all these trusts. One of the main or rather common or popular trusts is express trust. So express trust, basically, we always say there's a three certainty to create an express trust, meaning that I must make it very clear. What are the property? Who is the beneficiaries? And do I have intention to actually create a trust? Or actually, I just say it to actually please my girlfriend. Hey, I'm going to give this house to you. This is not an intention to create a trust. If I have an intention to create a trust, I probably will engage a lawyer to put it down in writing, and then I register at the High Court and then deposit at the land office. These acts will show the intention. If I have this intention, I make it very clear what is a property, I make it clear who is a beneficiary, then a trust will be crystallized. Immediately upon the trustee being signed. So this is something that just take note. Why do you need a trust then? Two reasons. Mainly to enable the property to be given to a person who may not have the capacity to hold the property. Let's say I have a kids happen to be so young, and I'm not sure after I pass away whether my beneficiary or rather even my executor will they actually take care of my kids or not. I want to make sure that my kids probably is well protected until age of 30. Then I can create a trust fund. I will appoint my executor or someone else, whoever I trust, to be the trustee. He or she will then hold this trust until my kids grow until 30 years old. So during this period, probably every month, my trustee will pay to my kids, let's say 5,000 a month. They will just keep doing it until my child reach 30. Then all the trust property inside, whatever balance left, I will just give everything to my kids. This is a way to make sure that my kids will not spend everything not according to my wish. So will it be better than will? To me, yes. If your intention is to ring fence the property from all your estate, this is a good way. So that you are very clear when you are still alive, when this trust is being created, I'm very clear that the moment a trust created, this money will definitely be out of touch of other people. Another reason is that we want to also protect the, let's say, unsound person. If I have a kid, again, with unsound mind, just unable to take care of himself, again, this trust will protect or at least make sure that he will be taken care well of reasonably until certain age. The other reason is more or less the same, is to protect the family property from all these squandering children through a protective trust. Everything will be there until you grow old. If not, or rather, if you fail to do certain thing I dislike, you are not entitled to the trust fund. I have a client actually have created a trust. The one of the condition is that none of you shall apply for non-Malaysian citizenship. If any of you actually try to be funny and apply for other citizenship, you are not entitled to any trust property. So then the kids need to decide, do I want to be a non-Malaysian or do I want the money? One of the solution is that you just wait until all the conditions satisfied. Take the money, then you decide whether you want to change your citizenship. But as of now, so long as you want your money, you must follow the contents of the trustee and act accordingly. The question is, who can be a trustee? A layman term, trustee, means someone I trust. But from a legal perspective, the trustee need to be someone who is of someone known by me, the best. I'm a settlor, being the creator of the trust. Someone known by me, the settlor, and someone who is of sound mind, and someone who is an adult. Can I ask a corporate body to be a trustee? Yes, but bear in mind that most of the time they will then charge the money, or rather the fees will be deducted from the trust property. So be it a public trustee or corporate trustee, or rather private trustee who is a company. Trustee, can a lawyer be a trustee? The answer is also yes. But most of the time, I will tell my client, please do not appoint me as your trustee. Appoint someone else you trust. Not because I don't trust myself, but rather, as a trustee, your duty and your obligation is very, very high. It's governed by the Trustee Act, as well as all other common law rules. If there is any, mismanagement or misdistribution of the trust fund, you may be exposed to the personal liability and be sued for breach of trust. Because as a trustee, you have very high duty. So some of your customer may say, hey, you are my agent. Do you mind to be my trustee? I trust you. Can you just take care of this trust fund for 5 years only? Just a very short period. Personally, I'm a bit conservative. I will just tell them that no, I do not want. The trustee, the obligation is too high. And even though they are willing to pay me X number of fees, I will just tell them no. I do not want to be expose myself to all this personal liability. But of course, if you happen to assume that role, kind of like, oh, you're very close to them, your friend, your family, you want to assume the role as a trustee, yes. Bear in mind, as a trustee, not only you have the duty, you also have a very, all the power under the Trustee Act 1949. The power include, you have a power to invest. Basically, provided that the deed of trust allow you to do so, please, if you are the trustee, make sure that you really understand the content of the trust deed. If the trust deed allow you to invest, you can invest it based on your personal view, as well as the decision made by a reasonable man. So make sure that when you invest, you are not going to invest it into scheme cepat kaya, not that type of scheme. You must use some decent skill as well as reasonable knowledge to invest. This is actually governed by the Trustee Act in Section 4 and 5. You also have the power to pay the trust money into the bank and other account. Basically, after the investment or whatnot, you have the power to actually pay to the respective beneficiary as you deem fit, but must not go against the trustee. Meaning you have wide power, but your power is not absolute. Always be mindful of the restriction in the trustee. Also, you have the power to settle any claims as a trustee because you are the guardians of the trust property. you also have the power to raise money. Raise money meaning that if you are the trustee for a property, let's say a house, you want to take good care of the house for a good 10 years. In your mind, it may not make sense. Then you can decide to sell the house and only hold the property or hold the money in the estate account, in the trustee account, in a trust account. Then you can distribute your money based on the trustee. But whatever I say is just a general power given to you by Trustee Act 1949. If the trustee say otherwise, please make sure you follow whatever stated in the trustee. Otherwise, you expose yourself to a potential liability to be sued for breach of trust. And next slide. What happened in the case of minor and people with unsound mind? For this part, I think citizens have covered as well. Minor, we actually have an Act of Majority, it's an Act of Majority 1971. This act actually defined generally minor means anyone below 18. But Trustee Act and Mental Health Act also have different definition. So the legal concept is that if you have a general act versus a specific act must always prevail. Like for example, FSA say that the nominee, the person who make nomination can be anyone above 16 years old. It is not that consistent with the Act of Majority because Act of Majority say 18 years is a cut-off age, but FSA says 16. FSA will prevail because this is a specific act for insurance or for banking all these financial institution purposes. I will address on some of the questions stated there shortly. Sorry. Okay. If you are below the age of majority, meaning you are have not actually reached 18 years old, you cannot prepare a will. So no minor or person of unsound mind.
Sorry for interruption, KB.
Yeah,
I
sure.
think you have unshared your slides. Yeah, can you share again your slides?
Oh, sorry, my bad. Give me 1 second. All right. Just a very quick one. Just now we mentioned that 18 years old is a cut-off age. So if you are below 18
sorry, KB.
Sure.
Sorry for your
Can you
interruption.
see the slide?
Yeah, but we can also see your next upcoming slide. Yeah, can you put it into the full screen?
Sure.
All right, thank you very much.
No problem. Sorry, give me 1 second.
Yep.
You'll be thinking why this young lawyer is not so bad with the computer. Is it better now? Still the same.
We can still see your multiple slides on right
the
side.
presenter.
Yeah.
Okay, give me 1 second.
KB, at the bottom of your screen, you see the percentage bar at the bottom. There's like
Right.
1% or something. Its left, there is a presentation mode. You can try clicking on that.
Okay.
At the bottom right corner of your PowerPoint.
His hand itchy, go and click on other button and this ended up like that.
Yeah, you find the presentation mode button. It looks like a screen.
Sorry, give me 1 second. Is it better now?
Yes.
Still the
Perfect.
same. Okay, cool. Sorry for the delay. So just now we actually stopped at the age of majority. So for will, only if you are minor or person of unsound mind, you are not qualified to prepare a will. And actually, for minor, it's quite clear. If you are just what do you call it, not an adult, you are not, and you are not supposed to prepare one. And you are a person of unsound mind is something more tricky in a sense that, based on our experience, most of the time when people actually challenge the will, normally it's on two grounds. One, the will was not properly prepared. But the second, the will was properly prepared, but the testator, when they prepare, they do not have the testamentary capacity, meaning that they are not there. I mean, their mind is not there to prepare the will. They are actually challenging their mental capacity. Do you actually have the ability to actually prepare the will when you put your pen down and sign the will? So these are the main reason. Like probably some of you will be the witness of your customer for a will. Just make sure that your customer actually have the mental capacity to prepare it. So because if someone actually challenge your will, if you happen to be the witness, the lawyer actually can subpoena you and bring you to the court to actually tell the court whether during the witness process you think the testator actually prepared the will with sufficient capacity or not. But of course, you are not a doctor. They will ask the doctor and all these other evidence. But you being the witness probably will be subject to this type of question as well. So for wasiat, I can't advise you on the actual requirements simply because I'm not a Sharia lawyer. But more or less, the requirements should be similar, meaning that you must be an adult and with sound mind. For trust, similarly, if you are not an adult, you do not have sound mind, I'm so sorry, you are not fit to be a trustee. Why? Because you, being a trustee, you are someone holding my money. I want to make sure that you perform certain competency and capability to take care of all this money. So they can be the beneficiary of a trust, yes. But if you are actually a minor or unsound mind, you can be the beneficiary. Most of the time, trust created to protect this category of people. Similar to the will, a trustee in a trust, you may hold and manage a property or asset on behalf of the minor until he attains the age of majority or even some other age. It could be age of 30, 50, 60, whatever you want. Just make sure you customize accordingly in your trustee. And the person of unsound mind until the season of his disability, or in any case, their earlier death. So these are the bare minimum. You can actually customize it accordingly. Basically, there is no template document available. Probably some lawyer or some advisor will tell you that, hey, everything you just copy paste. You can just get it from somewhere else. You can get it from ChatGPT. Most of the time, the answer is no, because you do not know who prepared the template. You do not know whether the template suit your situation or not. Always consult the advisor to make sure that the document is well prepared. For nomination and insurance policy, likewise, you can actually only nominate when you are age of 16 and above. If a nominee has not attained the age of 18 of unsound mind, the licensed insurer shall pay the blah, blah, blah. Okay, here we are talking about from a two perspective. One is policy owner being minor or of unsound mind. Another is the nominee themselves being minor and unsound mind, or unsound mind. So they actually have a different scenario. Policy owner, minor or unsound mind, sorry, you cannot nominate. But if nominee themselves as minor or unsound mind, we need to then fall back to Schedule 10 of FSA, which actually have already covered by Citizens earlier. So you just cross-check the Act. Of course, you want to look at the slide also can, but bear in mind that neither of our slide actually will be considered as legal advice. Just go back to the Act. The source of law itself will tell you the answer. EPF, similarly, if a person have not attained the age of 18 or of unsound mind, you cannot nominate. But if the nominee happen to be minor of unsound mind, then similarly, you need to go back to the source of law. Why we don't list down or rather summarize the law here is because they actually have different set of rule governing different situation. We do not want you to rely only on our slide and take this as a, let's say, a Bible and rely on it as a legal knowledge or textbook. So please go back to that regulation. And if you have any concern, please feel free to check with us or any of the legal counsel. Then we can actually tailor our legal solution based on your situation. Okay. The last part is on the make reference to FSA or Distribution Act. If you have not nominated anyone, what happened? Or rather, what would be the payment order of priority? Under the FSA, if there is no nomination, you first pay to the person entitled to policy money, and then the balance pay to the executor or administrator. If there is no executor, no administrator, you then pay to the spouse, child, and parents. But when we put this statement down, we actually quite hesitate, simply because the actual situation, actual scenario is very complicated, is very different. Please do not use this as a what you call that one size fit all answer for everything. Always make sure all the circumstances or scenario has been duly analyzed before you actually advise your customer. Okay. But of course, I'm sure GE have your internal internal document or internal SOP or protocol that will definitely be the best document for you to follow. So, okay, this is for Distribution Act, meaning that for all other estate, if you have not prepared a will, then the law have helped you to prescribe a formula how are you going to distribute all these assets. This was somehow covered by Susan earlier, and I'm supposed to actually complete whatever she said before. So Section 6.1 has made it very clear that property or asset shall be distributed in the following manner. These A to G is actually stated in the Act itself. It's not prepared by us. We can go through very quickly. If you only have a spouse, or rather only the spouse alive, and you do not have parents, you do not have issue, meaning that you do not have any kids. Whole estate go to your spouse. But if you have a spouse with parents without kids, spouse, you take half, and parents, you take half. But if you only have issue, your spouse pass away, your parents pass away, everything go to your issue equally. Meaning that if you have one kid, the kid will take 100%. If you have 5 kids, each of them take equally 20%. If you only parents only alive without spouse or issue, all go to the parents. And spouse or issue alive, spouse take 1/3 and issue take 2/3. The rationale behind is that the kids need more money. That's why they have 2/3 instead of divide equally. F, issue and parents alive. Similarly, the kids take 2/3, parents only 1/3. But if everyone is alive, then spouse only take a quarter, issue take half of it, and parents take a quarter. So the rationale behind the law actually makes sense. They want to protect your kids. But of course, the law can't customize according to your wish. If you want something special, something unique based on what you want, you prepare a will. If you do not have a will, the law will just create a blanket formula applied to everyone. If the following person are entitled in accordance with priority when the intestate meaning someone died without a will, without leaving a surviving spouse, child, or parent. If you happen to do not have all this category, but you are so rich, you need to find a way to distribute your asset after you pass away. First category, it will go to your siblings in equal share. If you do not have any siblings, your grandparents, your uncle and aunts, great-grandparents, and great-uncle and aunts, and eventually go to the government. Why we put it this way? Is it unfair? The way I see it is no. I wouldn't say it's unfair if you go to government, because eventually, in the very unlikely event, all this category from A to G as well as A to E not in existence, in a very unlikely event, your property somehow need to go somewhere. It cannot be just hanging there, no one actually taking care of it. So it will go to the government. But chances is very slim, because I think all the previous category have somehow covered everything. And for EPF, likewise, similar to insurance and Takaful, they have EPF Act and regulation. They will pay to personal representative. If you notice there's a trend among the insurer, the Takaful operator, or the EPF, they always pay to the personal representative. The whole idea is that, do you think that EPF and insurance and Takaful operator actually really care that much who the money go to? Technically, as a legal advisor for quite a number of financial institutions, I always tell them one thing. Your main concern is to discharge your liability, right? Your main concern is to avoid being sued, right? Your main concern is to close the account. You want to hit your KPI. You want to close the file. You just want to distribute the money. But who is the best person to get the money? The rule of thumb is go to the personal representative. Because these people, the executor, the administrator, they cannot utilize the money for their personal benefit. And it is their duty to identify who is the rightful recipient of the fund. So for you, for GE, release the money to them. Let them to decide who should they pay the money to. The moment you pass the money into the deposit into the estate account, your duty has been fully discharged, your job done. Let the personal representative to think or to actually find a solution how to distribute it. So that's why EPF take the same stand. FSA and IFSA take more or less the same stand. So yeah, that's it. Basically, nothing much from my end because I think Citizen Slide have somehow covered quite substantially. I will just pause my screen sharing here. But I know, okay, 1 second. Let me go through some of the questions that you all put. Can a person own self write a will with 2 witnesses? Answer is yes. But should you do that? I do not encourage because I noticed that my experience, I have a few scenarios. My client actually gave me a will with 1 page long. They have not covered quite a number of the essential items. Yes, the will is valid, properly signed in front of 2 witnesses. The 2 witnesses can be traced, but the problem is always the will only distribute half of the estate. The other half of the estate is not covered by the will and unable to be. I can't stretch the will further to cover those property. So the problem then, I have to get a letter of administration with a will annex and all this arrangement. So this is a part that you must be very careful. Just engage any of the professional to do it. It's not that expensive actually. To me, this is a document that governs all of your estate, all of your asset. Don't mind to spend probably a few hundred ringgit to get it done. That's how I always advise my client. Not so much because of the legal fees, because technically, I can be very frank to you, legal fee is not high to prepare the will. We normally do it for our friend and family and relative. Basically, it kind of like try to help them to manage the estate. Nominee is a wife, divorce, and no nomination update. If death occur, can an ex-wife claim the policy? Okay. To be very frank to you, I have no answer to you on this because it's subject to many circumstances on this. I think this part, we have to take it separately and we probably can give you an answer from this, but you need to let us know what is the actual circumstances. Then probably we can give you a proper legal advice on this. What about cash trust? As long as you have declared trust, I don't care inside there is a cash, it's an insurance policy, property, so long as it is a trust, you have ring-fenced it from your general estate. So it will be governed by the Trustee Act itself. Can beneficiary be a trustee? Can beneficiary be a trustee? Yes, you will wear 2 hats, but you need to be very careful when you actually how you manage the estate. So to protect yourself, if you are the only beneficiary, maybe not too bad because no one is going to sue you. If you have a few beneficiary and you are one of them, and you happen to be the only trustee, be mindful other beneficiary will go after you as a trustee if you do not distribute the property or manage the trust properly. So on this part, you must be very careful. Is there a minimum estate value to create a trust? No minimum value. You can just make sure that when the trust created, you probably just have a very practical idea. If you want to create a trust, what about the fees, the disbursement, or the reimbursement? Is it sufficient to cover it? And bear in mind, if you actually appoint a professional to manage a trust, the trust may last for a few years. So if ended up my trust fund, after I deduct all these expenses, actually worth nothing, then probably you need to find other way to manage your property. Next question, trustee and executor can be witness in will or not? My answer is always, please be very conservative. Get someone else to be the witness. Because if you are the executor of the will, if someone is going to challenge the will, most of the time, the executor may be someone to be actually challenged as well, being challenged as well. And who will be the one who give an independent evidence about the testamentary capacity of the testator, is about whether the will has been properly prepared, is some independent witnesses. So that's why we always tell my client, don't worry, I do not want to be your executor, but I'm happy to be your witness. If actually the court want to verify or want to check something, I'm happy to actually give evidence in court, being subpoenaed in court, but I do not want to wear too many hats. Try your best to make sure one individual only wear one hat. Don't make them wear multiple hats, because this is also a way to make sure that everything is properly done. Can we backdate a will? No. If you ask me, no, please do not do that. Simply because will is a last document you leave behind. If I die tomorrow, will is my last document. I can't even go to the court and tell the judge, wait a second, my actual intention is not like that. So this is my last document. And I do not want it to be challenged by anyone, even though a single risk. So do not backdate the will. And in fact, if you actually do that, people may think that, are you trying to be funny in managing the estate? You do not want to be actually exposed to that, the risk at all. Law firm provide trustee appointment and prepare trustee service. Yes, I believe many law firm will prepare such a services. But of course, we, the lawyer, are just sitting in the aircon room, prepare the document for you. But before you come to us, probably sit down and think about it, how you actually want to distribute it. Have a brief idea before you engage a lawyer. Then you can tell them your plan. Then let the lawyer or the professional do the job. They will then put everything down in writing. Make sure you check before you sign. Remember, when the trust being created, the trust materialized or crystallized upon its creation. So you need to be very careful. Technically, you cannot change it unless your beneficiary, your trustee actually have no objection to it. So you must be very careful. Witness can be an unknown person. Yeah, the answer is yes, but I will strongly discourage you to do it. Simply because if I have a will, I choose someone else, a stranger, to be my witness. I pass away, my executor bring this will to the court. The court will actually ask the witnesses to sign affidavit to say that they actually witnessed the signing of the will. You can't locate them. Then you become very troublesome to your family. When nominate a friend in EPF, can the wife challenge a nomination, or can the son challenge? Your money, you have the power to do whatever you want. They can't say much. But of course, if they want to, use moral high ground of family or whatever relationship to blackmail you, that's a different story. Legally, no. How much a power of attorney costs? There's no standard rate, no fixed rate. It really depends how complicated it is. It will be, the content of the power of attorney. So, yeah, so I have no answer to you on that part. Okay, I'll take the last two questions. Trustee is a lawyer, later his company bankrupt. What happened? There's no one-set answer for you on this. You may want to engage a lawyer and share the details fact with them and let them give you a proper advice on that. If witness pass away a few years later, good question. Is a very practical question. Okay, what happened is that if the witness actually pass away, okay, I pass away, my witness pass away. Let's say Cezanne is my executor. She will then check who is this the witness. If actually she can probably write to the law firm who prepare it. It could be their own lawyer to be the witness. Then they can easily trace them or locate them. If you really cannot find a witness, the court will expect the executor to take all reasonable effort to identify these witnesses. So it could be even to a certain extent make advertisement to locate the witness. If you really cannot locate them eventually after all the reasonable effort, then we will then tell the court, look, I have done this and this, but still I cannot locate them. Please give me a permission. I want to proceed with the to obtain a grant of probate. The court then will decide whether reasonable effort has been taken or not. So my advice to my client is always, it's okay. I can draft the will for you, and I'll make sure one or two of my lawyer will be your witnesses. So if anything happen, your family member can write to me. I'll try my best to locate them. After all, their lawyer or ex-lawyer, the bar counsel or our staff will have the record. So this is some practical tips when you prepare the will. So yeah, I think that's all from me. Nothing much, just some basic concept of how do you want to do estate planning. Mainly will and trust. Power attorney, I repeat, is a very good instrument if you know how to use it. If you do not know how to use it, it's a very dangerous instrument. It's a double-edged sword, the way I see it. Okay, if there's no further questions, Alex, over to you.
Yes, thank you very much, KB and Zizin for very wonderful sessions, very insightful. Very insightful sessions. Yeah, I'm sure that the agents have a very good away from these both your sessions. Now, for the agents, so please stay tuned because what I'm going to do is to launch the polling. Please get it completed before you actually leave the meetings room. Thank you very much. Thank you very much everybody for joining these sessions. Yeah, we have already launched the polling, so you all may start doing the polling. There are only 9 questions total. So once get it completed, then you all may leave the meeting room. Thank you very much, everybody.
Thanks, Alex, for arranging this, and thanks, everyone. I think KP and I will leave the meeting and let you do the internal things that you need to do.
Yes, you all may dismiss yourself from this
Okay, all right.
Thank
Webex
you.
training
Thank
platform.
you,
Thank you
everyone.
very much.
Have a nice day.
All right.
Bye-bye.
Feel
Bye.
free to let us know if there's anything we can assist you. All right.
Sure,
Thank you for
sure.
your time. Thanks. Bye.
Okay, for those that cannot do the polling, so let me share the slides again, how you should go about it, Just give me 1 second here. All right. Now, for those that are using the handphone, so what you need to do is to click the 3 dots button at the bottom of your handphone on right hand side. Right, once you click the 3 dots button, then you're able to see there's one advanced button on the next screen. So just click on advanced button. Then the next moment it will show you a Slido. Slido is actually SLIDO, just a green color symbol, a round shape with the S in within, yeah. Just click the Slido, then you're able to do your polling, right? Now, for those that using the PC, very similar function. What you need to do is to click the three dots button at the bottom of your this laptop on right side. Just click the three square button, then you'll be able to see the next screen that's on the Slido. Again, it's a green color circle with S in within. Then just click on the Slido, yeah. Then you're able to do your polling. Now the polling will look something like this for information. You need to click the Slido, then only these questions will appear. Then just answer accordingly. There were 9 questions, yeah. Then after completed, get it submitted, and you may leave the meeting room, yeah. Thank you very much, everybody, for your great participation in these training sessions.
Alex? Alex?
Yes.
Yeah, Alex, thank you so very much for arranging this training today and for getting 2 very experienced, knowledgeable lawyers, Tang Si Sing and Tay Kiam Boon.
Yes. Wow. You know their name very well.
Yeah, we have benefited immensely from this training, and we have been requesting for this training for a long time, many years, and finally the training was conducted today. We truly appreciate, Alex, your efforts, your work as the head of the training department. Thank you.
Thank you. Yeah, thank you very much for your presentation, yeah, on this training. I'm sure all agents also has benefited from this training as well. Yeah.
Very good. Excellent.
Hi, Alexa.
Yes.
Sorry, it's full. I would like to know the CPD hours will be.
Oh, there will be 4 CPD for these sessions. Yeah.
Because I find out that my CPD hours was not given, even though I've attended a few. So I don't know how.
Oh, can you check with your branch on this, because what happened is that the updating will be done by the branch and it will populate it in the system to be captured. It could be a bit of delay lah.
Oh.
A delay. Yeah. Yeah. No worries. Yeah. All right. Yeah. Okay. Yeah.
Hello, Alexa.
Yes. Yes.
We still cannot get a form, I'm afraid.
Get a form. Come again.
I mean, I still cannot do my what do you call.
I couldn't get what you said. Yeah. Can you repeat, please?
You're supposed to give our feedback, right? The form. I mean, it's in I still cannot get it.
Oh, there's it's actually a polling. It's called Slido. You're using a handphone or
Polling. Yeah, that's what I'm saying, polling.
or you're using a handphone or you're using your laptop.
Laptop.
If laptop, then can you see are you on the screen? I can share with you again how it looks like for easier understanding. Yeah.
Okay.
All right. Okay. If you are using a laptop,
I can't
sorry,
get it, the polling, yeah.
Yeah, let me just repeat again. If you are using the PC or laptop, right? Now, I have shown you a screen here. If you can see, there is a red arrow pointed here. There's actually a 3 dot buttons at the bottom of your this laptop on the right-hand side. Just have to click on it, yeah. Then it will show you a next screen. A next screen here, then it will show a Slido, which is a green color circle thing. All right, there's a S inside there. You just click the Slido, then you're able to actually do your polling. Now, for those that using the handphone, all right, then similar function here. Look at the 3 dots button at the bottom of the handphone on the right side. Just click on it, yeah. Then you're able to see the next screen, which show you there's one general icon and one advanced icon. Click on the advanced icon. Then the next screen, it will show you the Slido, the green color sort of the circle. Then just click on it, then you're able to start your polling. Right, yeah.
Correct. I
Yes,
cannot get the polling.
you still couldn't
Right.
get your polling. If you still couldn't get your polling, I think what